I would like to welcome you to this session. As per our agenda, it is on ensuring access to civil legal aid services. You might be wondering whether this is an appropriate session given the theme of the conference. The theme of the conference is access to criminal legal services. But we felt that this is an extremely important aspect of legal aid broadly. And it is an aspect of legal aid that does contribute to enhancing confidence, public confidence, in a legal system. And you are not able to generate that level of confidence in the system when you only focus on criminal legal aid. Now, out of this session, we are hoping that we will have a common understanding of what civil legal aid is, and try to establish whether indeed there is a demand for civil legal aid across the globe. Is it an African issue? Is it an issue for Europe? Is it an issue for Asia Pacific? Or is it an issue specific to Latin America? So we would like to kind of assess from these discussions whether there's a demand for civil legal aid, and question why there isn't so much attention being paid to this aspect of legal aid in comparison to criminal legal aid. In our day-to-day lives, you have women who are dealing with challenges about inheritance once their spouses pass on. Children need services. Young people, when they start up businesses, need some legal services to maneuver the administrative system for them to start up businesses. Elderly people are faced day to day on challenges about how to access their pension. So we have a number of civil matters, civil cases, and administrative challenges that ordinary people face on a day-to-day basis. So the question is, why are we not paying attention, or as much attention, to these issues, like we seem to be paying attention to legal aid in criminal matters? We have a panel of 4, and I'd like to introduce them to all of you. The first person I'd like to introduce is the Honorable Minister of Justice from Niger, Marou Amadou. He is the Minister of Justice and Attorney General of Niger, and he has a long history of activism and civilian leadership. Following the coup of 18 February 2010, he was appointed the transition chairman of the National Consultative Council. On the panel, we also have Erica Emdon, right at the far end, and she's the National Director of probono.org, which helps over 7,000 people per annum to gain pro bono legal assistance in South Africa. She has worked in the legal sector since the 1990s, and she's currently focusing on public interest law. The other member of the panel we have here is Ted Hill, right in the center. Ted Hill is the Country Director for South Sudan with the International Development Law Organization. He has 30 years professional experience in legal practice, project management, judicial and legal capacity building, and the academia. We were supposed to have Lloyd from the International Commission of Jurists, but he's not yet here, and we'll introduce him when he comes through. But the last member of the panel we have is Roman Romanov, correct? Roman is the Human Rights and Justice Program Initiative Director at the International Renaissance Foundation in Ukraine, and he previously was appointed the National Rule of Law Commission and the Criminal Justice Reform Working Group. And from 2006 to 2013, he provided assistance to Ukraine's Justice Ministry in establishing a legal aid system in Ukraine. And I'm Evelyn from the United Nations Development Program. Would like to start the discussion with the Minister. We've heard since yesterday that there are challenges around legal aid provision in terms of budget allocation and commitment to this area. Would like you to tell us what is happening in Niger in terms of civil legal aid, and what, from your perspective, needs to be done to gain traction around civil legal aid services from a political context.
to try to translate.
Je voudrais tout d'abord saluer tout le monde. Ah oui, d'accord. Merci, madame. Alors, je voudrais saluer tout le monde, en particulier les organisateurs de cette importante conférence.
The Minister would like to thank everybody, in particular the organizers of this very important conference.
Et la question de la prise en charge de l'assistance juridique et judiciaire des matières civiles au Niger, on ne peut en parler qu'au futur, puisque nous venons à peine en décembre 2011 d'adopter la loi qui permet de le faire.
Donc, in Nigeria, they're talking. Oh, pardon. And we've been saying in Niger, they can only talk about civil legal services looking forward to the future because the law has just been passed in 2011 and 11.
Comme dans beaucoup de pays, avant cette date, ce sont les ONG, les associations qui assistent à les cas dont Evelyne avait parlé, les femmes qui ont affaire à des questions de succession, des pauvres qui ont des problèmes champêtres. C'est toujours ces ONG avant cette date qui le faisaient.
Before, it was only NGOs providing these services, particularly for women in land rights. And vous avez donné un autre exemple?
Les enfants qui ont
children,
la garde des enfants, tout ça, ces cas-là étaient pris en charge par les ONG.
Okay, so family matters, land matters, civil matters were taken on by NGOs.
Mais moi j'étais arrivé au ministère en avril 2011 et convaincu que nous devons garantir l'universalité de l'accès à la justice. Il fallait une loi qui permette la prise en charge à la fois de l'assistance juridique en matière criminelle qu'en matière civile, parce qu'il n'y a pas de choix à faire quand les gens n'ont pas les moyens de se défendre.
So when he arrived at the ministry in 2011, he arrived convinced that they had to provide legal assistance in all cases for the poor, and there should be no difference between civil and criminal matters.
Et vraiment, toute la procédure législative, en passant par le gouvernement jusqu'à l'Assemblée, comme je vous l'ai dit, ça s'est passé en 6 mois avec la volonté du président de la République. On a pu régler ces problèmes.
So it took only 6 months to get the law passed with the help of the president, and now the law has been enacted.
Mais je dois dire aux gens que les députés n'acceptent pas toujours ça facilement. Je voudrais expliquer parce que beaucoup auront, je pense, à l'avenir engagé de telles démarches législatives. Il faut savoir convaincre l'Assemblée nationale parce que pour tout le monde, ça coûte énormément cher.
So while they got the legislation through, the members of parliament were not always in favor of this because it costs so much money, and he would like to talk about, some of the challenges in convincing members of parliament to pass this legislation, to agree with it.
Juste pour l'histoire, j'ai dû rappeler aux députés que autant on ne doit pas rester insensible à ceux qui ont faim ou qui sont malades, on ne peut pas être insensible à ceux dont les causes ne peuvent pas être entendues en justice.
He explained to them that just as one should care about people who are hungry or sick, we should care equally about people who have problems in the justice sector.
Donc, une fois que cette loi est adoptée, et conformément aux principes et orientations des Nations Unies vraiment, et peut-être que nous, on a fait cette loi un peu avant, mais vraiment, nous sommes conformes aux principes. L'universalité est garantie pour tout le monde, la gratuité est garantie et la responsabilité incombe à l'État et à ses partenaires éventuels.
The law is very much is consistent with the principles and guidelines of the UN, but was passed earlier, and it provides universality, free services,
et l'agence est indépendante.
And independent agency to provide the service.
Et nous avons dû aussi adopter des textes complémentaires sur les personnes indigentes, les personnes vulnérables, qui a accès, dans quelles conditions.
And there was additional legislation or regulation as to who is entitled to the service for indigenous populations, etc.
Et c'est pas moins de 6 décrets et 3 qui restent à être adoptés pour que ça soit effectif.
So there's six decrees have been passed, and there, combien de plus?
Il reste encore 3.
There's 3 more to go. Allez-y, vous avez 5 minutes.
Et bon, je pense que je vais plutôt répondre aux questions, c'est de dire aux gens quand même que ce n'est pas un processus facile, mais que nous devons avoir foi que dans les affaires civiles également, quand quelqu'un a une cause qui ne peut pas être entendue parce qu'il n'a pas les moyens ou parce qu'il ne peut pas être défendu, eh bien, l'état de droit pour ces personnes-là est tout simplement une comédie.
So it's not that he would prefer to answer questions, so he has time left, but he wants to make sure that, to make the point that civil legal services are important as our criminal defense services, and without, it makes the justice system a bit of a comedy. Thank you.
Thank you.
Thank you very much, Honorable Minister. Hopefully, as the discussion continues, we'll get a few more pointers about what we could do to try and gain political commitment to this aspect. I would like to turn to Romanov. Ukraine's legal aid system is also developing. What is happening in Ukraine? Can you comment about?
Okay, thank you for this set of questions. I'll try to address all of them, but actually I have 3 key messages. So first of all, I think that the state, which is ready to promote civil legal aid, is really doing exactly in the way to ensure the national ownership. And I will opt the legal aid reform and legal aid system, and I will try to prove that first message. The second is that, as for me, the civil legal aid is very much linked to the trust of people. So for criminal legal aid, actually people have no choice. They just need assistance. They just need a lawyer. But to be effective with non-criminal legal aid, the trust of the people is crucial. And if your system is trusted enough by the people, this is the key to the trust for the whole legal system of the country. This is my second point, which I wanted to raise and to prove. And then actually, the effective civil legal aid is a way to promote the justice concept as a whole instead of administrative power. And I think this last message could be very clearly illustrated by the current situation in Ukraine. So in the Soviet past, we had a very influential institution, which is the prosecutorial office, which has lots of functions outside the criminal justice system, including the general oversight. Now it's been transferred to the oversight over human rights violations and legal representation as well. So having such a multifunctional body, which is directly linked to the top leaders of the country, so the prosecutor general in my country is appointed by the president. In the eyes of many people, the prosecutorial office is exactly the structure. There they can address their needs. Why? Not because they are effective in representing the people before the courts, but they have administrative power. So what people expect from them? Mostly just to have a phone and to make a call and to find a quick solution. And it's not necessarily the legal solution, which is like people expect in the system that they trust to the rules of the country. actually to understand how deep is this alienation of the citizens and the legal system of the country. 3 years ago, we conducted a study, which was conducted in 5 regions of Ukraine, mostly in the small communities. And we were trying to understand the level of trust and what is the legal capacity of the population, what kind of legal issues are the most important for them. So outside any criminal convictions and the criminal law area. And what is the source of legal advice and legal information for them? And what is the best way, how they see the solution for their problems they meet in their life. So we found out that actually 83% of the polled said that wealthy definitely have the privilege in our courts and legal system for sure, as they believe in that. Actually, we had the same amount of people who said that if any legal problem would arise in their life, they would try to find a lawyer and to go to the court. And the same number of people said, no, we would prefer to rely upon personal relations, bribery, corruption, organized crime, everything else. But never go to the court, never use the legal system of the country, because it's not effective, we don't trust them. So I think this is a very worrying situation, and we decided that actually it's something what we have to address through the government and through many other stakeholders. I think that civil legal aid is quite easy to promote politically, because to raise funds for criminal legal aid, it takes lots of effort. And many politicians, and especially, economists within the ministries would say, like, sorry, we have to spend such a huge amount of money for just criminals. That's not the way. Why? But for civil, I think that, politically, especially for MPs, it looks like, quite okay for them to promote the civil legal aid and to show that they care about the real needs of the people who are their voters, actually. At the same time, it's not enough to establish the system which is functional. I would say it's even more challenging than the system on criminal legal aid. The reforms in my part of the world, in Eastern Europe and former Soviet Union countries, started with criminal legal aid, first of all because they were actively promoted by internationals and because there are clear international standards, commitments, which countries have to meet. But they do not exist in the same way for non-criminal matters and non-criminal legal aid. So it means that if we would be able to find the solutions and the way how to establish the functional legal aid in civil matters, it's real the real national ownership, and this is the promotion of national ways how to deal with the people's needs and their will actually to address those needs, to meet them. In Ukraine, we found a way that actually there are 4 levels of legal aid system in the country which could make them functional. And since the system was established just 1.5 years ago, of course, there are lots of gaps. But just in a few words, so we have the National Legal Aid Institution. Then we have in all the regions of Ukraine so-called managerial units, which are regional legal aid centers. They are in charge of appointing the ex officio lawyers for criminal cases, and they run 24 hours a day duty solicitors scheme from the time of detention for everyone. The third level is does not exist yet, but it's prescribed already by law, and according to the transitional provisions, it's postponed for 1 year. These are interregional legal offices. They are mostly the civil and administrative matters would be solved, and we're supposed to have hired full-time lawyers as well as ex-officio lawyers for all these matters. And then this is the community level for mostly primary legal aid. And this is something what we started to work with, and we established 43 community law centers in different communities, which are directly funded now by their communities, by their local councils. These are the units which are the closest to the people. As I said, this is extremely important to establish trust, because we don't have this culture that before signing the contract, people call to the lawyer and ask an advice, whether I should put my signature here or not. What are the risks? Usually people sign and then identify the problem and then try to find a solution. So this is a part, unfortunately, of legal culture in my part of the world, which is, I think, common for not only for Eastern Europe. And just we wanted to promote that the smallest issues are important. Go to advice, free of charge, everyone. We cannot ensure your legal representation, but we will give you advice and information on any matter you need, just before something has happened. And of course, it's directly linked to alternative dispute resolutions, which has to be offered, because sometimes if the court system is not very much effective from the point of view of the time and the result, people in many cases, especially the neighborhood conflicts, would be much more happy to find a solution through the mediation or other means. So, and in the smallest communities, we do have a kind of paralegals or individuals who are hired by local communities, who can provide some basic advice, not, of course, legal representation. So there is one significant gap, which is now these interregional offices for court representation in non-criminal matters, which we hope to be established by the government within 1 year as a part of the prosecutorial reform, and that all these functions of legal representation from the prosecutor office would be transferred to the legal aid system. Thank you very much.
Moving on to Ted. We'd like to hear about South Sudan. Very clearly, there seems to be a demand for civil legal aid in Niger, in Ukraine. Is that the same scenario in South Sudan? And if it's the same scenario in South Sudan, are there any civil legal aid schemes that are functional, effective, and operational? If they are not there, from your vantage point and where you sit, what would you see as some of the key issues in terms of prioritizing civil legal aid, allocating resources for it, and ensuring that the resources that are allocated to this generate value for money and have the greatest impact, particularly at policy and very strategic levels?
Thank you very much. With respect to South Sudan, as I'm sure you're all aware, South Sudan has been in a state of conflict for about the last 7 months. And so perhaps I can speak to the situation just prior to that conflict. And I'll speak very briefly because I'd like to move on to the second part of what you've asked. South Sudan is undergoing what we could call a paradigm shift. The whole legal system is changing, is changing from a Sharia hybrid continental system to a common law system, and that officially at least was done overnight. At the same time, there is an official language change from Arabic to English overnight. And so you can imagine the demands that places on justice institutions and so on. This is in a country where there is very low capacity and very low resources So in a nutshell, to answer your first question, I'm sure there would be a demand for civil legal aid. Certainly there are a lot of disempowered people who would be able to benefit from it. Unfortunately, civil legal aid does not exist in South Sudan. Criminal legal aid barely exists. One of my colleagues from UNDP will be speaking a little more about that tomorrow. We at IDLO recently, and which is to say before the conflict, we're working with the University Law School to develop a clinical legal education program, which would have, and perhaps will in the future, address some of the legal aid needs, both criminal and civil. So, moving on to the second part of your question, what I'd like to do is to draw some comparisons between criminal legal aid and civil legal aid. And to do that, I'd like to, first of all, acknowledge that the vast majority of resources go to criminal legal aid, and there may be very good reasons for that. I don't want to get into that debate right now, but in some countries there is civil legal aid. In South Africa, where we are right now, we heard this morning in the Philippines, and some other countries, indeed there is civil legal aid. But I'd like to imagine a hypothetical situation where a country or a jurisdiction decides that they are persuaded that there should be resources devoted to civil legal aid that weren't previously allocated. And so the challenge then is to decide, assuming we are those who have been given those resources, and assuming it's a finite amount of money, how do we allocate those resources within civil legal aid? And I think one of the first questions that we probably ask ourselves is, well, how do we divide it between legal education, legal literacy, awareness, those types of initiatives that may not require the services of a lawyer? And on the other hand, what proportion of those resources that we've been given should we devote to services that do require a lawyer or legal input? And assuming that we have answered that question, in other words, we've decided that a certain proportion should be devoted to legal awareness, legal literacy, and so on and so forth, then we're left with the remainder, which is the amount that should be devoted to civil legal aid services where a lawyer is required. That is, a lawyer either just providing legal advice or perhaps also providing representation in a court or before a tribunal. Compared to criminal law, I would suggest that it's a much more difficult question. In criminal law, it's fairly clear, at least in most jurisdictions, that if someone does not have the resources to hire a lawyer, is in custody, or is facing a possible period of incarceration, then they should be entitled to legal aid. And it's probably close to universal that those are the three criteria that are applied to establish criminal legal aid. However, civil legal aid where a lawyer is required is a little bit more complex, I would suggest, because while we can still apply the means test, there is unlikely to be any period of incarceration. A civil client isn't going to be spending time in jail when they're applying for civil legal aid. So how do we decide if we just open the door and say, if you pass the means test and you have a civil problem that requires the services of a lawyer, we're here at your service. And that might produce an excessive demand for services such that people who are considered more deserving aren't represented and people who are less deserving. So the question is, who is deserving? And there's different ways that we can answer that question. One of them, I mentioned the means test, of course, which is universal across civil and criminal. But we might say, okay, well, what type of case should entitle a person to civil legal aid where a lawyer is required. And some of the possible answers to that, I think, are fairly obvious. In a case of perhaps domestic violence, cases where a person is dealing with an application relating to their own mental health that may result in a loss of freedom. Those sorts of cases I don't think would be terribly contentious. Perhaps also cases where a person can't afford a lawyer and they're engaged in a landlord-tenant dispute and they may lose their home and their family's home. That also may not be particularly contentious. Wrongful dismissal, where someone's livelihood is on the line. Perhaps that is also a case where we would all agree that someone who can't afford a lawyer should be entitled to one. But then you get into some other areas. What about defamation? What about trademark claims, or as you mentioned, registering possible intellectual property things? Should they be entitled to a legal aid lawyer? What about a medical malpractice case, which requires possibly years and an extreme amount of resources? Breach of contract, and so on, and you can imagine many other types. So it would be necessary for us to decide, unless we were to say all cases, to develop a policy and then apply that policy to screen out certain types of cases. Another question that we might ask ourselves is, should we represent plaintiffs or should we represent defendants? A defendant, of course, in a civil case has no choice. That person finds themselves engaged in a dispute and they require a lawyer. You might say, well, a plaintiff, on the other hand, has a choice. And so perhaps we should favor defendants who are dragged into a dispute before a court, where others are not. I see I'm running out of time. There are a number of other factors. One of them is the strength of the case. If we were to ask anyone who would like to engage in civil litigation, who can't afford a lawyer, and perhaps whose case falls within the initial screening we did about type of case, should we be representing everyone? Or should we be examining the merits of the case? Is it frivolous? Is there any chance of success? And so on and so forth. So the other thing to keep in mind, I think, is that when one party can afford a lawyer and the other party cannot afford a lawyer, and the system funds only one of two people, you can create a power imbalance. The dynamics of civil litigation are such that the cost of the litigation is a real factor in rationally deciding whether to take the case forward, whether to settle the case, whether to discontinue the case, or whether to take it to trial. And those are very real factors that are applied by people, and if you're paying for a lawyer out of your own pocket, then you make decisions accordingly. If the state is providing you with a lawyer, then those decisions may not be relevant, unless the system is nuanced enough to take that into account. And so in allocating resources, there's a whole lot of questions around that as well. I was going to speak also about ways of achieving greater value for money for those cases that do go ahead. And I will just briefly list some of those, just for the purposes of perhaps stimulating discussion. Cases that will affect beneficially a greater number of people will achieve a greater or higher level of impact. For instance, an example might be a zoning change, land use, where 100 or 1,000 people might be affected. Applying state resources to civil legal aid in that sort of case would have potentially a lot greater impact than some other types of cases. Same as a case where there's a failure to enforce safety standards by the government. One person represented the outcome of that case can affect hundreds or perhaps even thousands of people. And in common law systems, there is the consideration of precedence. The fact that from a strategic point of view, taking cases that may establish a precedent, which will then form part of the law, and may indirectly or directly over a period of time not only shape the law but help other people indirectly, may be another way of achieving greater impact. And I think I've used my time, so...
Thank you so much, Ted. We would like to go to the South African experience. We've heard that your systems are quite developed, particularly in terms of providing criminal legal aid services. What is the experience with civil legal aid services, Erica? And when you speak about your experience, would like to hear how it works and what you see as some of the challenges that you've faced over time, and to what extent your legal services in civil matters have contributed to shaping or informing strategic discussions, as Ted just talked about, or even creating policy and legislative change.
Thank you very much. Thank you very much too for inviting me to be part of this panel and be part of a conference on the criminal justice legal aid system, despite the fact that I work primarily in the civil legal system. And I think that this session today is a very important session, and I may as well state up front that I believe that a criminal legal aid system and a civil legal aid system are equally important, and that we should not prioritize one over the other. So going into the experience that I bring to the table, I've been part of an NGO called probono.org, which is a legal civil case clearinghouse. Well, what that means is that we identify cases and clients, we assess them, and then we pass them on to private attorneys to do on a private basis as pro bono, which means for free, in case any of you didn't grow up with Latin, for their clients. So the history of pro bono, which is really free civil service, is that in around 2002, a discussion started taking place in South Africa about the fact that many, many people were not afforded representation in civil matters. There are a number of legal NGOs which have been here since the days of apartheid. However, they started losing their funding slowly because the emphasis or the interest in apartheid dwindled among international donors, and so that a gap appeared in regard to civil cases and representation of people civilly. So the whole concept of pro bono developed in around the early 2000 period and has grown substantially. We are a legal clearinghouse which sees about 7,000 cases. Legal Aid South Africa commits about 10% of its resources to civil representation. And then private law firms, very large private law firms, the 7 or 8 largest private law firms in the country. So there's definitely been a growth, but this is not state funded. This is from the private sector or the NGO sector, civil society. Whether the state should fund civil legal aid is an interesting question, because I find in my experience and the experience of the other legal NGOs and the pro bono departments that we end up often litigating against the state at different levels, and there could be a conflict in civil matters if we end up, sorry, this is really not such a great speaker, can I try yours? It keeps buzzing, which is pretty good. Thank you. This one's not on.
It's on.
Is it? Okay, that's better. Can you hear me? So the problem that we face here is that I don't know if I believe that civil legal aid should be state funded, and I think that's something that would be interesting to hear from other people today. Obviously, one of the reasons that one wants a strong civil legal aid representation in civil matters is that poor people and impoverished and marginalized people in the country frequently need assistance in civil matters. And I think we've had a list of what those kind of matters are. Just to add that in South Africa, refugees are a big component of what of a group we work with who need civil aid services. So we mentioned consumer domestic violence, maintenance and all of those, but I just wanted to add to the picture refugees. So the point here is that poor people daily experience situations where they run up against either big corporates or government or bad administrative segments of government where they really need assistance, legal assistance. And maybe not litigation, it could be less, it could be more advice. What I find is that out of our 7,000 cases that we see a year, only 10% end up in litigation with attorneys. The rest actually get dealt with more at a paralegal level, with advice being given. I think that the challenges that we face in trying to extend civil representation through pro bono work for the private legal sector is to convince private attorneys that this is something they ought to do. The law societies have passed rules in 2010 in which, and same with the bar councils. Remember, we have a split bar in South Africa, so we have advocates and attorneys with different representative structures. So in 2010, rules were passed compelling attorneys to do 24 pro bono hours a year, and compelling the bar councils, 3 bar councils have passed rules compelling advocates to do 20 hours per year, which is really very little, but it's something. And it has helped. It has helped certainly with us working in this field to recruit more lawyers and to get lawyers more on board more easily, especially smaller firms and lawyers in smaller towns in the far-flung provinces. However, I don't really believe rules are the way to actually convince lawyers to do pro bono work. I think what's more important is to build a culture of pro bono and to get lawyers to sort of identify with fairness, concepts of justice, concepts of putting something back, concepts of using their legal training for the betterment of the social good. And a lot of those values can be instilled in the legal profession through constant recognition of pro bono work and through use of the media and other resources to complement and to build up the legal profession and try and create a feel-good atmosphere around doing pro bono work. And we have found that this has been highly successful. We started out in 2006 with about 15 law firms on board, and we now have about 250. And we've worked in 2 provinces extensively, which is KZN, with an office in Durban and Johannesburg. But we've also branched out into the Popo and far-flung areas of Gauteng, working closely with community advice officers. They are paralegal organizations working on at the grassroots level, and working with them is aimed at empowering them to some extent through education and support, but also taking cases that they get and allocating them to private lawyers in their areas. So we try as far as possible to extend this concept of pro bono out of the big firms which have the resources to do it, through to smaller firms, through to areas in rural areas and small towns. So in order to do that, it's an incredibly expensive and difficult process, and we being an NGO rely completely on money from foundations that get no state funding whatsoever. And obviously that's a challenge. A challenge is to build up civil representation organizations that are sustainable in a situation where you don't have state support. And while I have said that I don't believe states should fund this kind of organization, on the other hand, I do think there are some situations where state funding could be of assistance and state support also. Just to end up, I just want to say that Legal Aid South Africa, our hosts actually, have been very innovative this year I think they copied our model, but I won't say that too loudly, and have introduced their own pro bono scheme, which works almost identically to ours. It's based on volunteerism, so they ask attorneys in their networks to volunteer to take on cases on a pro bono basis. They keep statistics on the hours, which we do, and they report their hours to the law societies, which we do. And so in that way, they're extending their reach of civil representation. And I think it's a great scheme. It's national, whereas we're only working in a couple of provinces. And it'll vastly improve access. And it goes with the whole concept that we're trying to build up in the country of building pro bono as a way to give people access to civil representation. I just wanted to say a few points in relation to some of the points raised by the speakers. I just want to respond to some of the points. I really thought that this the point that was made by one of the speakers about trust is very important. I do believe in this country, when it comes to trusting the legal system as a way to solving problems, we do have difficulties in South Africa, and people do want to look at other mechanisms like corruption, taking the law into their own hands, and that we have to build up a trust very much in the legal system from the grassroots up. And part of building that trust is that people have good representation and can trust that they will be given high quality representation. And I think that's one of the challenges that we have in South Africa. My time is up.
Thank you very much, Erica. From the panel members, all right, give the whole panel a round of applause. From the 4 panel members, you can see that civil legal aid schemes and initiatives are at different stages of development. But what is clear is that there's a demand for it. It's challenging to try and get people to pay attention to it, whether governments or even civil society organizations. And the question is, for those countries that already have schemes in place, we've had the community-based initiatives in Ukraine, we've heard about what South Africa is doing, what can be done to scale up those initiatives? But even more importantly, in countries where this has not yet gained traction, what needs to be done at the political level, at a policy level, and at a practice level to ensure that we increase the attention to be paid to civil, quality, effective legal aid services. And in doing that, we'd be very happy to hear from you about your country experiences. So I'd like to open the discussion up. And we would like to hear very practical solutions on how we can take this forward, and so that we can also include it in the outcome document. Yes, Christine from Uganda. Any other person?
Thank you very much, Evelyn. My name is Christine, and I come from Uganda, and I work for a government program on legal aid. When we are talking about legal aid in Uganda, we don't even make a distinction between criminal legal aid and civil legal aid, because we recognize that we need both. And I wanted us to come out of this room with a very, very strong, clear sort of point that should make its way into the main document that we are going to come up with, that it's critically important to think about civil legal aid. And here I think a lot about Africa. And when I hear our colleagues talk, I see that we are talking at different levels. And I want us to critically think about Africa and think about, and I don't know whose village we can use here, but think about the remotest village in Africa, where in Uganda, let me use Uganda, where a rural old woman grows her garden of maize, and then a middleman comes and says, I would like to buy it, I'll go sell it and bring you back the money. It's a commercial issue, okay? But the man goes and never comes back. But he's around, he can be found, and civil action can be brought against him. But this woman cannot afford the services of a lawyer to be able to get that money back. I want us to think a lot about the fact that where I come from in Uganda, in an ordinary court, 70% of all the litigants in civil cases are unrepresented. And I want us to think about the fact that when there are 70% of all the cases in the court unrepresented, that translates into case backlog, because they really can't process these cases through the court. I want us to think a lot about the fact that If I use my own country, 67% of all the people in Uganda are vulnerable to poverty. And if they are, it means thinking about access to justice is a luxury, okay, if there's no civil legal aid. I want us to think about the fact that 70 to 80% of all agricultural produce in my country, and I know it's representative of Africa, all agricultural produce in Uganda is done by women, and not women like me and Evelyn or Erica. It's done by rural women. And if they are supporting our economy to the scale of 70 to 80%, and we're an agricultural country, and when they get into legal problems, there is no legal aid in civil cases, I don't know if we are being fair. And I want us to think about the fact that we must make the connection between legal aid and economic development. And here I'm really thinking civil legal aid. I want us to think about the fact that when we think about healthcare, when we think about education, we must think about access to justice. And we must think about civil legal aid more than we even think about criminal legal aid. I could say more and more and more. But I won't. I want to ask Erica a question though. How do you get the law firms interested in providing pro bono services? Thank you.
All right.
Good afternoon to everyone. It's again Ukraine, not peaceful Ukraine. My name is Catherine Karmazina. I represent the attorneys of my country, and also I work in the university as an associated professor. I thank a lot to Mr. Roman Romanov for his great description of how the civil legal aid is being provided in my country. And yes, all what he told is truth, and I would like to share some additional experience of providing free of charge legal aid in Ukraine and the role of attorneys in this procedure. So, first of all, as it was already told, at the moment we cannot talk about providing free of charge legal aid in civil cases by the, let's call them public defenders, as well as I am, because according to the plans we had to do it. We had to begin from the 1st of January 2013, but because of the huge lack of funds, financial sources, etc., we postponed that till 1st of January 2015. But if to ask my opinion, I don't think we will begin. So there are a lot of people...
Why do you think you won't begin?
Again, funds problem. I think this is the problem of any country, I'm sure. But still, we have a lot of categories of people and a lot of categories of civil cases where the provision of free legal aid is needed. So what are we doing now? How are we solving this problem now? Since 2004, we have the rule. This is an official paper which was issued by the Ministry of Science and Education. According to this rule, it's obligatory for all the law schools, all of our universities, academies, institutes who are preparing future lawyers, who are giving higher education, to open inside those universities, etc., law clinics. And it's obligatory to choose the best students from the third year of education and higher, and to give them teachers who are supervising their job, giving advices. And those law clinics really are the only ones who are doing so much about free legal aid provision in civil cases. Though normally they should check up whether the person has a right on free legal aid or not, they don't do so. So anyone, no matter what is the financial situation of that person, no matter what is the subject of civil case, can come to law clinic in Ukraine, can ask any kind of question related to civil case, to administrative case, and can get help. What kind of help? It can be oral consultation. It can be making easy kind of papers. It can be even, though it shouldn't be, it can be even application to the court and even the appeal claims, though it mustn't be. About attorneys.
Just a minute so that we have others also contributing.
Yeah, okay. I'm sorry. So on 2011, there was adopted a law on free legal aid, according to which it was written that only the public defenders has a right to supply free legal aid on the conditions which are written in the law. So at the moment, all the lawyers who are not working with the government and who decided to provide pro bono legal aid in civil, administrative, other types of cases, they are actually risking, because, well, okay, they can write into a contract that the legal aid is being applied pro bono, means they don't get anything, they're not paid, but later, the state authorities like tax office and other financial inspections can come and ask, why you did it? You were not appointed for that. So what I propose in our final document to specify the specific role of law clinics in providing free of charge legal aid in civil, in administrative cases, until the country will not find the necessary funds to pay for this job for lawyers, and also to specify the great role in this process for all the attorneys, call them official lawyers, of all the countries of the world. Thank you. Sorry to take so much attention.
All right, thank you.
I'm Megan Waters. I work at the West African Law Institute in the Gambia. We're a recently established NGO that's in the country to help basically develop the general legal system within the country, which is at the moment very, very poor. The Gambia has passed a number of different legislations, one being the Legal Aid Act, which actually does provide for civil legal aid. The problem that we're having right now, and my question for the panel would be, I've been contracted recently by UNDP to sort of review this act, look at provisions of this act, and see what needs to be improved. One of our major points of interest is the development of the means threshold, because as my sister from Uganda said, I think the U.S. Embassy in the Gambia recently estimated that approximately 90% of the population there would actually qualify for legal services based on what the threshold the government was originally proposing is. And this goes hand in hand with the fact that private lawyers are basically charging about 60 to 70% of the average monthly income just for a 30-minute consultation. So that taken in mind, I wanted to know sort of from the panel your suggestions as to setting a means test, particularly considering the large agricultural nature of the country, particularly including the fact that most families typically decide just on what they grow and their own sort of personal farming mechanisms. There's not really monetary income.
I believe that in criminal and civil, civil is as important as criminal. In Mauritius, the civil and criminal legal aid system exists since 1973, and I personally believe, and I have seen it in court every day in my work, civil is as demanding as in criminal cases. And the question arises is whether we should set up guidelines with regard to civil cases, whether we are going to allow all type of cases, because otherwise the courts are going to be flooded with applicants. I think there should be a threshold. We have the means test in Mauritius, like for example, somebody earning a salary of $300, and if he has property of, let's say, $15,000, beneath that amount, he will be given legal aid. But apart from the mean threshold, I believe there should be other tests to be determined. For example, before somebody applies for a legal aid, he will be sent to a lawyer, and the lawyer is going to give his opinion. We call it an opinion, whether he has a good case or not. Just like the representative of Sudan, South Sudan, has explained. And I believe that we should come up, if the UN can come up with guidelines and best practices in civil cases. Thank you.
My name is Vuka Shabalala. I'm the retired Judge President of KwaZulu-Natal. I hear that pro bono is done in South Africa, but in my province, it is not so. But what I did, I spoke to the regional manager, because I think basically legal aid practitioners are very, very thin on civil work. Very, very thin. They're thin on criminal work, they're thin, even worse thin on civil work. Now, I suggested that I will talk to the chairman of the Bar Council, that the legal aid practitioners, they must select them those who have got better qualifications to attend the Bar Council lectures. The chairman of the Bar Council agreed. Now, that would have made a big difference if that was followed up, because the Bar Council exam is very, very wide. They do all sorts of work. They read a lot of case law, and it's a very thorough qualification to practice as an advocate. So I think there's one way of accessing legal aid for civil work. Now the other thing is that there was in the past what's called, I think it's still there, but it's not used as much. It will be something similar to pro bono. It used to be called informa pauperis, whereby advocates were giving work for without pay. Now, the legal aid could do that, provided they've got the personnel to do civil work. I'm afraid they don't at the present moment. Because civil work has got to do with pleadings and so on, exceptions and whatnot, the rules of court and so on. There's so much to learn in civil work than in criminal cases. So I think personally that legal aid must take this challenge and cooperate with the bar councils so as to get a proper qualified practitioners who can then do civil work, even if it's pro bono. But I know in Pietermaritzburg, for instance, there are a number of advocates who are members of the legal aid. They do civil work. So, and I think it's because they are qualified to do it. I think that's my legal contribution.
Je suis directeur de l'Agence nationale de l'assistance juridique et judiciaire.
Okay, he's the director of legal aid in Niger.
Alors, nous n'avons pas beaucoup de temps, je vais intervenir très rapidement.
He's going to go fast.
Le ministre, son Excellence, Monsieur le ministre de la Justice du Niger, a parlé de la volonté politique tout à l'heure. Il y a eu effectivement une volonté politique. Et dans la salle, j'ai cru comprendre à travers les différentes interventions que nous sommes tous d'accord sur le fait que autant l'assistance ou l'aide juridique en matière pénale est importante, autant on peut relever cette importance en matière civile.
He's recognizing the political will in Niger for providing legal services, and he also sees the unanimity in the room on equating, making no difference between civil and criminal legal services.
Alors toute la difficulté, c'est à partir du moment où on a l'effectivité normative, il faut passer à l'effectivité en tant que telle, rendre cela applicable. Je crois que c'est toute la difficulté de la question.
So the next step is implementation in Niger.
Alors, il faut comprendre qu'il y a deux aspects de la question à voir. Et avant la naissance de tout différent, les personnes qui ont vocation à être assistées ont besoin d'être conseillées, orientées, dirigées, parfois aussi aidées dans la rédaction de certains actes. Alors il faut d'abord régler ce problème-là avant de voir le problème de l'assistance lorsque ces personnes sont dans le cadre d'un différend, d'un conflit avec d'autres personnes ou avec l'administration.
Excusez-moi, la première étape, c'est...
La première étape, j'ai dit qu'il faut faire une distinction. Et des personnes qui ont besoin d'être assistées dans la rédaction de certains actes, dans la compréhension de certains problèmes de droit, dans l'orientation ou de la compréhension de certaines démarches administratives qu'il faut effectuer.
So he sees the matter in two steps. The first step is to identify what the person needs, the person who is requiring services, if it's just assistance, if it's actually filing things in court, or if it's just assistance.
Alors, cet aspect de la question, si vous voulez, il est important parce que quand on prend le cas de la plupart des pays, en tout cas les pays africains, on a le problème de l'analphabétisme. L'analphabétisme fait que les personnes ne peuvent pas accéder directement aux administrations, ne peuvent pas accéder directement à la justice, elles ont besoin d'être conseillées. orientés.
And he makes the point of, in Africa, there is such a huge amount of illiteracy that these basic services of understanding an act and drafting a letter are basic needs.
Alors pour toutes ces personnes-là, donc pour l'expérience que nous sommes en train de mettre en œuvre au Niger, toutes ces personnes peuvent se présenter devant un bureau d'assistance juridique et judiciaire et obtenir l'encadrement nécessaire pour faire les démarches administratives ou pour avoir des explications sur tel ou tel aspect du droit, avant même la naissance d'un différend ou d'un procès.
So all these people can come and seek advice before any kind of legal claim is involved or even an issue.
D'accord.
Somebody's whispering in his ear.
All right, one more minute.
Évidemment, pour régler le problème de la qualité des personnes qui doivent faire ces prestations, donc nous avons pensé qu'il fallait, si vous voulez, trouver des personnes qui vont travailler au sein des bureaux locaux, qui ont une certaine culture juridique, une certaine culture de l'administration, ou qui ont au moins le niveau de l'assistance et de la licence en droit, à défaut d'avoir, si vous voulez, des avocats de manière permanente au niveau des...
For those people and for their requirements to provide these basic services, they don't require actual lawyers, but they require a degree, the first degree in law. That's, yeah.
Maintenant, lorsque les personnes ont réellement indifférent en matière civile et qu'elles ont besoin d'être assistées, là aussi, l'expérience que nous sommes en train de mettre en œuvre, c'est de faire en sorte qu'elles puissent être assistées gratuitement, donc par la désignation d'un avocat au niveau du bureau d'assistance juridique et judiciaire, ou à défaut d'un avocat, de trouver vraiment des personnes qui ont une certaine expérience du droit, que nous appelons les conseils d'office, qui assurent cette défense-là, les personnes vulnérables.
So that seems to be the first is where people are illiterate and need basic assistance. Then there's the next step, which is a conseiller juridique that can help the person in deciding in a matter or whether there is a matter or not. And then they want to be able to provide services by a lawyer in court and litigation. This is the goal because they're looking for.
Voilà, donc c'est cette expérience-là que nous sommes en train de mettre, cette structure que nous sommes en train de mettre progressivement en place. Et nous pensons avec cela avoir l'universalité de la couverture, quel que soit le degré de vulnérabilité de la personne, quel que soit son alphabétisme, quelle que soit son indigence, elle pourra trouver d'abord conseil au niveau des bureaux d'assistance juridique et judiciaire. Et lorsqu'elle est en phase de procès, elle pourra être assistée par un avocat ou par un défenseur commis d'office.
My name is Fatima Lehe. I'm the pro bono manager at a corporate law firm called Bowman Gilfillan, which is one of the largest corporate law firms in this country. And I thought that you would find it interesting to see how we have dealt with our pro bono. We have an average of about 400 lawyers, and our firm not only must we comply with what the Law Society requests lawyers to do, but we have a policy, internal policy, through which every lawyer must give 50 hours of their time per year towards pro bono work. We do work with Erica's organization very closely, over and above which we also have our own clinic, our own flagship. Because we are a corporate law firm, we've aligned our pro bono work with economic empowerment. So what we do is that we give corporate pro bono legal services to small businesses and startups with a turnover of no more than R1 million. And what we do is we would do anything from IP matters where we partnered with another large corporate law firm called Adams who would register anything relating to IP. We do partnership agreements, shareholders agreements, etc. We also run various clinics together with probono.org as well as from our Cape Town office. But it is important for me to say that the bill for civil legal aid is really carried by the firm itself. So including my own salary, which is really, I'm the only non-billable lawyer in the firm. And that is the way we manage pro bono services and how we bring about access to justice for the poor. So at this point, we don't have much, we don't really look forward to the fact that there would be anything from the state regarding civil legal aid. Thank you very much.
Yes, good afternoon. My name is Mimi Melka. I come from the Law Society of South Africa. the body that regulates all the attorneys in the Republic of South Africa. To respond to the issue that was raised about whether there would be a possible conflict of interest for the state to fund civil legal aid. It's a fact that right now the state is providing funds to Legal Aid South Africa to do civil legal work, because the state has also realized that there is actually a huge need out there for people to get assistance with civil legal aid. And most of the people, like the rest of Africa in this country, cannot afford the services of private attorneys. But also, there is, if I can put it, a mind shift in the profession as well of attorneys. In fact, before there were even rules implemented, because remember, this country might seem like a developed country in all of Africa, but it's in the rest of Africa, and so the dynamics are the same. So even before there were rules promulgated to force attorneys to do pro bono work, we find that pre-apartheid, before 1994, the small lawyers were always there in their communities doing this pro bono work. Pro bono work didn't mean they had to go and represent people in courts, but people used to come to lawyers to get legal advice about civil matters. And I think it's not only peculiar to South Africa. I think in other jurisdictions as well, lawyers do provide free legal services, legal advice to people in the communities. It's just that there was no formal documentation of such. And I think this exists in all the other countries. Last point, I think the reason why it doesn't, civil legal aid doesn't seem to get impetus in all jurisdictions is that there is no focus on the rights of accused persons who are arrested. And so, in most jurisdictions, it is a constitutional imperative to give people who are arrested rights to attorneys. So it is not spelled out clearly that people also have a right to civil legal aid. So when institutions who want to render legal, civil legal aid services go to government to fund us, but in particular to government, to ask for funds to do civil legal aid, the first thing they will encounter is, well, is it a constitutional imperative? Because first we must do what is an imperative in terms of the law. And then we must fund that as a priority. Thereafter, we'll then look at the social problems that people have, including the problems that they have in civil legal aid. So that's probably why civil legal aid hasn't gained such imperatives as one would expect. Thank you.
All right, we'll get back to the panel members. There are some specific questions to each one of you, but I'd like you also to give us your last word in terms of what could be done for us to advocate for or campaign for increased attention and visibility for civil legal aid. Whether or not that provision is in our constitution or not. We'll start with Erica.
I'm going to try and be quick because I'm sure the other panelists have things to say. I just want to start with the last point, which is the LSSA point. Just to say there is a provision in the Constitution which does say that every person is entitled to representation in a forum, whether it be a law court or in any other alternative dispute forum. So I think we need to sort of perhaps highlight that section of our Constitution, which I quote as often as I can. Just to also comment on a number of people have mentioned this whole concept of screening, of assessing cases before they go to lawyers. And I think that's a very important point. And I think as far as South Africa is concerned, we've developed a pro bono, and I know that the LSSA is supporting this as well now, the concept of the 90-minute consultation, that concept that a person needs to have really excellent assistance for at least an hour and a half, and during that period, that's when one starts to assess what happens to the case, where it should go. Should it go to the Department of Housing, Department of Health, or should it get a lawyer to litigate, or should the person who's doing that first consultation make a phone call and write a letter? So that's a very important part of the pro bono concept and the Law Society concept of pro bono as well. When it asks lawyers to do pro bono work through its system, it accounts that 90-minute consultation as pro bono work. I wanted to also respond to the person from Sri Lanka. I think, and also the LSA person, I think I might have been simplistic around the concept that the state can't fund civil legal aid. And I think that it's a complex question, and I do think it can, under certain circumstances, if that kind of independence that you mentioned is secured. So, I mean, you've convinced me, and many people have convinced me. I just wish probono.org could get some state funding. That would help. Then I just wanted to also say that I think that the concept of the one first question I was asked, which is how do you get lawyers interested in pro bono work? It's a complex issue. We've had rules since 2010, but as has been mentioned, there has been pro bono work done, in fact, for decades, right back into apartheid. And I certainly believe that the small firms that are all sprinkled around the country do masses of pro bono work which is not even recognized, because they get instructions from very impoverished clients and have really no option but to take those cases on. Some of them now are reporting hours to get recognition, but that starts to become very relevant. So I think getting lawyers really involved there and getting them committed in a big, long-term sort of way requires a lot of promotion of pro bono in the whole society. One needs to actually build a culture, and one wants people to want to be doing it because it feels good and it looks good, and it's a nice thing to do. I know a lot of the big firms in America, for example, and even some of the big firms here, have internal reward systems for pro bono work done by their lawyers, and sometimes associates can't be promoted without demonstrating the number of pro bono hours they did in a particular year. But obviously in small firms, different parameters need to be established. But those are just some of my comments as a response, and I need to give the other panelists a turn. Thank you.
Romano, any response and any last word?
Yeah, lots of thoughtful comments, and I want just to pick up one suggestion, like how we can move forward, what kind of issues we can raise further, especially at the level of the UN. So from all these comments, questions, and stories we have heard, I think we can just accept that really the demand is far away from all the offers we already have, and we have to accept the multi-stakeholder approach towards the non-criminal legal aid, so that the paralegals practices, the community-based services, legal clinics, NGOs, pro bono practices, and government state legal aid, all of them actually have the place all together. And what kind of combination? It's, I think, the question for each national jurisdiction. And I don't think we are ready to start drafting some principles or standards for civil legal aid, and these discussions just give me this feeling that maybe not, but at least to start working on best practices, which we hear a lot here already. I think it's exactly the time. So my suggestion would be just try to promote, like the UNDP and other UN agencies, maybe to try to compile lots of different practices from national jurisdictions, which could give us more ideas for the next steps forward. But we are somehow at that stage. I have that feeling after this session. Thank you.
Ted?
Thank you very much. The comment from the woman from Uganda and Zambia both referred to high levels of poverty. I think if I understood correctly, it was 90% in Zambia and 60% in Uganda, but it doesn't matter. It's not an exact thing. The point is that an overwhelming number of people in certain countries cannot afford a lawyer. And when it comes to civil legal aid, unless you refine, if you're dealing with a finite amount of resources, which hopefully will increase, but assume that there's a finite amount, then the only way to accommodate people across every type of case is to tighten up the eligibility rules. And after a certain point, if a person is living in a subsistence level, it becomes artificial, it becomes arbitrary to try to finesse the eligibility to a point where you're ranking people who the group is living in a subsistence level. And I think that gets back to the need to prioritize types of cases, unfortunately. And I think the priority of cases ought to be the extent to which they have an impact which is linked to social development in the larger sense. And I think that answers the other question to some extent about what direction should people be taking to advance civil legal aid, and that is to link it as much as possible to social development. Thank you.
Honourable Minister.
I will try to conclude in English. Really, to advocacy for legal aid in criminal cases or civil cases, I think we have a conviction that we cannot have democracy or development without rule of law. You cannot have rule of law without an independent and accessible justice, which can deliver and make decisions in good time for all people. So I think the challenge is about money, means to invest in these things. Our common destiny is democracy and development. We should pay for this. Thank you very much.
Thank you very much, Honourable Minister. And I would like to thank members of the panel, but before we give them a final round of applause, I'd just like to summarize 3 key messages that have come out of this session. The first one is that civil legal aid is as important as criminal legal aid, and there shouldn't really be a distinction of this in your national jurisdictions in terms of interventions and in terms of support. However, in civil legal aid, it might be necessary to prioritize certain matters depending on your national contexts and as the demands still arise. And in order to respond, we need to have a multi-stakeholder approach to be adopted in response. The second issue is about civil legal aid being a key enabler for access to justice, for the rule of law, and obviously for growth and human development. And therefore, one of our strategies should be to link civil legal aid to issues of growth and development. The third one is the possibility for studying the area to develop best practice, which could inform the next steps after this meeting. And the next steps could include the need to develop guidelines on how to take this matter forward in your different jurisdictions. So those are the key 3 messages that I take out of this. The rest are details in terms of what a legal aid scheme could look like, and based on different country experiences. I'd like us to give a round of applause to our panel.